Hello, am I audible? Good morning, everyone. Firstly, I am very thankful to all participants for joining with us. A warm welcome to all the attendees, esteemed guests, and all faculty members, also participants who have gathered here for this insightful seminar on patenting in pharmaceuticals, challenges and case studies. So, firstly, I am Bhosle Sujata, currently working as an assistant professor at Adarsh Shikshan Prasarak Mandals, KT Patil College of Pharmacy, DHARASHIV. It is my pleasure to be your host. Today, we delve into this crucial topic that impacts innovations, research, and the pharmaceutical industry at large. Pharmaceutical patents play a pivotal role in fostering innovations while ensuring that public health needs are met. However, challenges such as regulatory hurdles, ethical concern, and legal complexities often arises. Throughout the day, we will explore these aspects with industry experts, researchers, and legal professions who have extensive experience in this field. Now, I would like to invite the head of quality assurance and chief coordinator of this seminar, Dr. Aruna Devi Biradar ma'am, to present a brief agenda
Yes, Salman.
about today's seminar and introduce our guest in shortly. So, please ma'am, present your presentation.
Yeah. Good morning, all of you. Good morning, everybody, respected dignitaries, esteemed speakers, and dear faculty members and enthusiastic participants. It is my absolute privilege to welcome you all to this very exciting seminar on the patenting in pharmaceuticals, challenges and case studies. Myself, Dr. Aruna Devi Shantappa Birajdar, working as a professor in K.T. Patil College of Pharmacy, Dharashu, since last 14 years. And today's program, I am working as a chief coordinator of this event. It gives me immense pleasure to see such an enthusiastic gathering of the students, researchers, and professionals eager to explore the world of pharmaceutical patent. Today's rapidly evolving pharmaceutical landscape, the intellectual property right play an crucial role in the safeguarding innovation and driving the advancement in the healthcare. However, navigating the patenting process comes with its own set of the challenges from legal complexities to strategic consideration. To shed the light on these critical aspects, we have and with us an esteemed panel of the experts who brings a wealth of knowledge and experience in the intellectual property and pharmaceutical patenting. Now, intellectual property or IP, it refers to the legal rights granted to individual or the organization for their creation and innovation. It serves as a crucial mechanism for the protecting inventions, artistic work, and the brand identities, as well as the proprietary knowledge. In the pharmaceutical industry, the intellectual property plays key category of IP, which includes the patents, trademarks, copyrights, and trade secrets. While trademarks protect the brand name and the logos of the pharmaceutical product, ensuring the authenticity and consumers' trust. Wish to keep undisclosed. The intellectual property of trade secrets are the confidential formulations, unique manufacturing processes, and the companies who are doing the research work. The intellectual property law helps to maintain the balance between the promoting innovation and the ensuring public access to the essential medicines. Among all these forms of the intellectual property Patents are the most significant in the pharmaceutical sector. So patent is an exclusive right granted to anyone the using or selling the innovation without permission. So the patent life is about 20 years from the date of filing. Am I audible properly?
Yes, ma'am, you are audible.
Yeah. So there are different types of the patents in the pharmaceutical, each serving a unique purpose. That is lead patents, which are most common functional aspect of the new drug formulation and manufacturing methods. Next is a process patent, safeguarding the innovative drug production techniques, ensuring the companies can appearance or packaging of the pharmaceutical products. So design patents which protect the unique shape and appearance of the product, such as inhalers, tablets, design and the common companies. There are certain evergreen patents are also there, where the minor modification to the existing drug, such as the new dosage formulation, delivery mechanism, or packaging, patents are essential for driving the innovation. So today we are going to focus on these topics. Let me take the opportunity to introduce briefly about them. In morning session, the Dr. Mahesh Jadhav sir, who is the CEO of the IP Intellect Services Pune, is a visionary leader in the field of intellectual property. His expertise in the patent filing, prosecution, and has the instrumental in the shaping of the IP strategies of the various pharmaceutical organization. Next speaker is a Ankita Sharma, serving as a IP manager at Emprex Private Limited, Pune. She is actively involved in the patent analysis, drafting, and portfolio management, helping the pharmaceutical companies navigate the intensive patenting process effectively. In afternoon session, the advocate Gauri Bodu madam, she is the legal head of the IP Intellect Service Pune. She has the extensive background in the IP law and has the plays a pro vital role in the guiding pharmaceutical firms through the complexities of the patenting and legal complaints. So we are truly honored to have them with us today, and I am assured that their insights and case studies will provide us with a deeper understanding of the challenges and strategies of the pharmaceutical patenting. patenting. Before beginning of this program, I would like to express my sincere gratitude towards our management of K.T. Patil College of Pharmacy, the Chairman Sudhir Anna Patil, Office Superintendent, that is the all organizer committee, and the persons who are directly or indirectly work for this uh, tireless work for making this event possible. Let us commence this engaging and informative session. Now, I will give once again thankful to all the participants and wish to have a fruitful learning experience of this seminar. So thank you one and all. Now I will hand over to the um, madam, that is Bhosle madam. Please carry on. Thank you.
Okay. Thank you, ma'am, for
Bhosle
giving
madam.
the. Yes, ma'am. Yes. Thank you, ma'am. Thank you so much for giving a brief information about the patenting in pharmaceuticals and case studies, also challenges in patenting. So thank you very much. Also, you give introduction about our today's guests. So I'm very thankful to you, ma'am. Now, I request to all participants, if you have any queries or questions during the presentation, please type them into the chat box. After the presentation, we will address your doubts into the question and answering session. So now, on behalf of other Shikshan Prasarak Mandals, K.T. Patil, College of Pharmacy, Dharashiv, K.T. Patil, College of Pharmacy, Dharashiv, I welcome to today's guest, Dr. Mahesh Jadhav, sir. So, welcome, sir. With extensive experience in the pharmaceutical patent and legal frameworks, Mr. Jadhav will provide valuable insight into the evolving landscape of pharmaceutical intellectual properties. Currently, he is serving as a CEO at Intellect Services, Pune. He has completed his PhD in pharmaceutical science and holds an M.Pharmacy in Pharmacognosy and Phytochemistry department from Pune University. Additionally, he has postgraduate diploma in intellect property rights from IIER Delhi. He is a registered patent and trademark agent at the Indian Patent Office, Mumbai. His industry experience includes working with renowned pharmaceutical companies such as Agenta Pharma, Encure Pharmaceuticals, and FDC, etc. He has successfully filed more than 1,500 patents across India, the USA, also Europe, Brazil, Mexico, Thailand, and Canada. Additionally, he has filed more than 2,000 trademarks, more than 500 copyrights, and several design patents. Now, I request to Dr. Mahesh Jadhav, sir, to begin his session without further delay. So, please, sir, start your session.
Thank you, ma'am, for the kind introduction. I will share my screen.
Okay, sir.
So, thank you, ma'am, for the kind introduction. Firstly, I would like to thank our honorable principal, Dr. Aman Joshi, sir, and Chief Coordinator, Madam Birajdar, and also all teaching staff for inviting me for today's session. So, the before starting the today's session, I will disclaim that this presentation and video is intended for the educational purpose only and not for commercial use. The photographs and videos included in this videos are for educational and information purpose. So today we will discuss the monitoring the innovations, the strategies age of IPR career. So agenda of today's presentation is the we will discuss very brief introduction about the intellectual property rights. Then we will discuss the IPR classification, where we will see the brief introduction and the filing procedures of the patent, trademark, copyright, design, geographical indications, plant breeding rights. Okay. Then after that, we will see the types of the patent applications, then types of the trademarks. Further, we will see the patent filing procedure in India. After that, in a second part, we will discuss the career opportunity in IPR, how you will get entry in the IPR field, role of IP person in the pharma industry. That we will discuss very briefly. After that, we will see the as a central government, there are many positions are there like patent agent examination, trademark agent examination, then patent examiners is there. Various posts are available at Indian Patent Office that also we will discuss in today's presentation. So we will discuss one by one very, very briefly. The first one, the intellectual property rights. The word, there are three words are there: intellectual property rights. Okay, the words intellectual, the intellectual means creations of the things, come up with anything which is new, novel, innovative, that is intellectual. Okay, anything which is new, novel, innovative, unconventional approach, that is comes under the intellectual. Okay, though intellectual also as a problem solving approach is also covered in the intellectual. Any new concept, new process, new inventions, new instrument, new designs, that is also comes under the intellectual. So we will discuss the intellectual property rights in for forthcoming slide. The second word is the property. Property means there are two types of the property: tangible and intangible property. Tangible property means physical property. IPR comes under the intangible property. Okay, so that property is transferred from one person to another person, that is the rights. Means rights mean the transfer of property, any property, that is physical property, tangible, intangible property, that we can transfer from one person to another person, one person to legal entity. Okay, so IPR is also one property that we can transfer from one person to another person, one person to legal entity, or one legal entity to another legal entity. That is rights. Also rights to transfer, rent, hire, mortgage. Okay, the selling, offering to the sale. These are all IP rights. IP rights owner having the rights to transfer from one person to another person. So these three words are very much important in intellectual property rights. So intellectual property rights are the rights granted by the government, okay, to creators or owners of the work in terms of the scientific work, industrial work, literacy, artistic work, films, poems, novel, designs, new logos, new symbols, new names. Okay, uh, includes the patent, trademark, copyright, designs, anything that is comes under the intellectual property right. Okay, so we will see the brief introduction about the IPR classification. The very first class is the trademark. Trademarks means anything which new logo, names, symbols, taglines that covers under the trademark. We will discuss in further slide. After that, we will see the patent. Patent means anything which new inventions, new instrument, new apparatus, new process, compositions, that covers under the anything which is new uh, in terms of the invention, that covers under the patent. After that, the copyright. Copyright means literacy, artistic work, that is covered under the copyright. The industrial designs, design registrations cover the anything which is new designs, that covers under the industrial designs. Geographical indications. Then we will discuss the trade secrets, plant breeding rights. Okay, or IPR classification we will see one by one. So intellectual property right, the very first class is the trademark. A trademark may consist of the word, designs, letters, symbols, packaging, signs, slogans, taglines. Okay, all covers under the trademark. While seeing this logo on screen, we can easily identify the which brands covers under this logo. Okay, the first one logo is Starbucks, then Shell Petrol, then after that the MACD, Apple, Nike. Okay, while seeing this logo, we can easily identify the which brands covers under this logo. Without writing any name on logo, we can easily identify because of the power of the trademark. Okay, they have registered their logos under the trademark, so we can easily understand the which brands covers under this trademark. Okay, so, as per the Trademark Act, Section 2ZP, the trademark definition of the trademark is the capable of being represented graphically, which is capable of distinguishing the goods or services from one person to another person. Okay, so it is easily distinguished from one person to another person. That only we will get the trademark in terms of the shape of the good, packaging, color combinations. Okay, so these are the examples of the trademark, like shape of the Coca-Cola bottle is covered under the trademark. Then packaging, it's like Kit Kat, Cadbury. These are all packaging of chocolates covers under the trademark. Color combinations in terms of the Netflix. If you see open the Netflix, then you will we will see the color combination that is covered under the trademark. So as per the Indian Trademark Act, definition of the trademark is very first criteria is it should be represented graphically, and second word is it is easily distinguished from goods or services from one person to another person. Okay. After that, we will see the what is mark. Mark includes the device brands, headings, labels, ticket, name, any signatures, words, any new words, letters, numericals, shape of the good, packaging or color combinations or combination thereof. Is these all includes the mark as per the definitions of the Trademark Act Section 2M. The mark is cover the any device. Okay, so these are the some examples of the mark, okay, like Tata, Coca-Cola, Mercedes, BMW. Okay, these are the some devices and logos or symbols that covers under the trademark. So what is understanding of the trademark? The trademark means anything which is new, novel, innovative words, logos, symbols, okay, that is distinctive and which is distinguishes of goods or services from one person to another person. That is a trademark. Okay. The life of the trademark is 10 years, but we can renew it after every 10 years. Okay, so we can use it lifetime after interval of the renewals, and it is graphically represent. Okay, these are the some examples of the trademark. So further we will see the characteristics of the trademark. The very first is the it should be fanciful or coin trademarks. Okay, if your mark is fanciful and coin trademark, then it is the strongest mark. Okay, made up of invented words to be used as a trademark. Like example is Kodak. Okay, second one is arbitrary trademark. Arbitrary trademarks means having a real meaning, completely unrelated to the goods and services. Okay, this Apple is comes under the food category, but it this Apple brands is registered trademark under electronic category. Okay, so these are the arbitrary marks. Then suggestive marks, names after characteristics on products, nature of services. That is the Netflix is the videos. Okay, so it suggests the marks, uh, suggests the trademarks. Okay, sorry. So in the classification, suggestive marks is the name after the characteristics of the product or nature of services. Then after that, descriptive marks. Descriptive marks means having the slight connection to the product services without actually describing it. Okay, like example is the jet airway. While seeing the jet airway, we can easily recognize this service is related to the airways, aeroplanes. Okay, then generic trademark. Generic trademark means describe the entire product or services. That is a aqua water purifier. Okay, this brands is related to the water. Okay, we can easily identify that this mark is covered under the water category. So after that, we will see the types of the trademark application. The very first type is the conventional application. Second is the unconventional application. Conventional application means the marks include the letter, numericals, logos, then description, symbols. Okay, these are covers under the some conventional trademark. Unconventional means modern marks which don't falls in the category of any pre-existing conventional marks. Example is the like sound mark, smell mark, test mark. Okay, we will see one by one. So conventional trademarks again divided into four different types. There is a word mark, device mark, certification mark, collective marks. Okay, word marks means the words, it is the broadest protections of the trademark, like Dell, Sony, Samsung. Okay, these words are registered under word marks in a trademark. Okay, so after that we will see the device mark. Okay, these are the some examples: Coca-Cola, Mercedes-Benz, Starbucks. Okay, Nike, Apple. These are the some logos mark. Certification marks means certain quality of the products is authorized by using a certain authority, that is a ISO mark, ISI mark, CE mark, Halal mark, WHO, GMP. These all certifications are also comes under the types of the trademark. Okay. After that, we will see the collective marks. Collective marks means the certain groups of peoples comes under one unique logo. That is a example is the charter accountant, company secretary, advocates, doctors. Okay, these are the some group of peoples comes under one unique logo. Then unconventional trademarks again divided into two types. That is a visual mark and a non-visual marks. Visual marks include the 3D shape of the good, like Coca-Cola bottles. Okay, the shape of the Cadbury, shape of the Kit Kat. Then color combinations. Then motion mark. Motion means if you open the Netflix video, it's some motions creations is there, that is a protected under the motion mark. Holograms, pattern marks, position marks. Position mark, the best example is the Levi jeans. Okay, so these visual marks include the shape, color, motion, hologram, patterns, positions. Non-visual marks are again divided into four types. That is the olfactory marks, sound mark, taste mark, touch mark. Okay, sound marks, the best example is the Yahoo. Okay, taste also we can protect under trademark, but in India only the sound mark protection is there. Taste mark, texture mark, touch mark is not yet protected in India. The important definition of the certification mark. The certification marks is the specific aspects of the mark having the goods or services indicating that the manufacturing of the goods or services has tested and verified strict compliance with the certain prescribed standards. Okay, means some products having the certain uh, quality and the manufacturing quality is authorized by using a certain authority with some standard operating procedures. Okay, that like ISI mark, ISO mark, CE marking. So these are the some examples of the certification marks. Collective marks means the collective mark is a trademark capable of distinguishing goods or services of members of organizations of persons, which is the owner of the trademark from those of others. Okay, means certain groups of people comes under one unique logo, that is collective marks. Then again, the next definition is the well-known marks. Okay, well-known mark is a mark which has become a substantially to a segment of the public which uses and receives such goods or services, that the use of such mark in relation to the goods or services which likely to be taken indicating the connection between those goods or services and person using this mark in relation to the first mentioned goods or services. Okay, means one brand is taken the whole categories goodwill. Okay, like example is a Bisleri, Toyota, Colgate, Bata. Okay, Xerox. These are just some examples of the well-known mark. Then second part is the class. Okay, according to the business category, this classification is divided based on the niche classification of the goods and services. The goods covers under the class 1 to 35, services covers under the 36 to 45. Okay, here is some example like the if you wanted to register your product in a pharmaceutical category, then we need to register our trademark in class 5. If cosmetics products is there, then class 3. Agriculture product is there, then class 1. Then stationery is there, then class 16. If clothing related brands is there, then class 25. If food category is there, the class 30. If milk category is there, the class 29. Okay, so according to business category, the classification is divided into two part. One is the goods and services, in terms of if you wanted to register your pharmaceutical services, then we need to register our trademark in class 44. If you are in hotel industry, restaurant industry, then class 43. If you are in a legal services, then class 45. If you are doing general business, general trading, business offices, then online portals, then general class is the class 35. If you wanted to register your financial services, then we need to register in class 36. Okay, so these according to your business classification, this classification is there. And after that we will see the trademark search. Okay, based on the your mark is already registered or not, we will see on public search of the trademark office site. It is freely available to all of you, so anyone can check on this site their mark is unique or not. Okay, so the next, after searching, if you find your mark is innovative, your mark is coin, your mark is new, then you can do trademark drafting, that is trademark filing. Okay, it comes in terms of the filing online trademark application with registration through form TMA. Okay, and with relevant zonal official trademark registry along with all necessary documents. Okay, So, if you wanted to your mark is expedite, then you can file TMM, and you can mark your you can expedite the processing of the trademark application through filing form TMM. Okay. The what is the fees for the trademark application? Official fee for individual startup and small scale, it is 4,500, but it is a large scale industry, then for fees is 9,000. Okay. After that, after filing the first your mark, then you will get either your mark will be directly accepted, or you will get first examination report. Okay. Once you receive the first examination report, then you need to reply within 1 month to the trademark registry. Okay. If you fail to reply within 1 month, then your mark will be abandoned. Okay. After that, after applying the your trademark, then trademark examiner will examine your application, and it will be after that it will be direct accepted, or control may ask you for hearing. Okay. If your mark is accepted, then it will be published in trademark office journal. It remains in trademark office journal for 4 months for third party opposition. If no any third party opposition received during the 4 month, then your mark will be registered, and after 10 years you need to just renew that trademark. Okay. But once you get hearing notice, you need to appear for the hearing. After hearing, your mark will be either accepted or refused. Okay. If your mark is accepted, then it will again publish in trademark office journal. After publishing, it remains 4 months for the open for the third party opposition. If no any third party opposition is received, then your mark will be registered. Okay. And it will publish in trademark office journal. Okay. So after getting your mark is registered, you can write on your mark is R. Okay. But while filing, you can use TM only. Okay. Lastly, the certification of the trademark registration is granted by the relevant office of the trademark registry to the applicant. After getting this certification, exclusive ownership over the mark is ensured, along with the rights related with commercial use and the legal protection. Okay. Here we will see the one short video.
This is Vaughn. He's a student studying psychology and a world-class baker. All his friends and fellow classmates love his secret family recipe, dollar chip cookies. He began to package and sell the cookies on campus with a catchy slogan, "A warm bite of home." Due to popular demand, Vaughn ended up with a real business on his hands. This is Janet. She is also a student, majoring in mathematics, and she loves active outdoor activities like running, hiking, and biking. One day, she sketches an idea for a novel sustainable wearable that keeps her in exercise mode when she can't make it to the great outdoors. After building a prototype using her school's Maker Lab, testing it with her friends, and researching manufacturing options, Janet realized that she's now an inventor. This is Matthias. He's a lifelong craftsman taking evening classes at his local community college to build his business and entrepreneurship skills. After researching competitors, his new business plan is to convert vintage fabrics into beautiful tote bags. Soon, Matthias launches an online shop complete with a trendy logo. Vaughn, Janet, and Matthias's stories touch on 4 types of intellectual property, or IP. What is intellectual property? Simply put, it is any intangible creation of the mind and is essential to business and creative endeavors. The Michelson Institute for Intellectual Property is a nonprofit initiative with a free curriculum, resources, and network of experts to help with your IP education needs. Join our growing community of educators and learners on the journey to creatorship today at michelsonip.com/start-here.
So what is the conclusion of this video? Actually, this video covers the three startup businesses. Okay. IP protection is a powerful tool that helps the small startup, okay, in terms of the protect their innovations from being copied. Okay. Attract the funding and the partnership by providing originality, build the strong brand identity and customers trust, earn positive income through licensing and franchises, okay, expand globally with legal protection in international markets. So investing in IP early gives the startup in competitive edge and the long term success is the conclusion of this video. So next classification is the copyright, okay. So, copyright is a legal term describing rights given to the creators for their literacy and artistic work. Literacy work includes the novel, poem, books, film story. Okay, any one concept is there. If you write in your own language, that is also covers under the literacy work. Artistic work means any videos, films, songs that covers under the artistic work. The next classification is the plant breeding rights. As India is agriculture country, so not much more protection is given to the plant breeding rights. Next IPR classification is the industrial designs. Okay, any new designs that is covers under the industrial designs. Like examples is the Soxhlet apparatus, any dissolution test apparatus, any designs which is new, novel, and some having the some commercial use that we can register under the design registration. Here the term of the design registration is the 10 year. After 10 year, you can renew it. So various designs is covers under the design registration. The filing procedure of the design is similar to the like trademark. Okay, the very first is the searching, design searching. After that, the filing. After filing, examination is there. After examination, your design registration is registered at the Indian Patent Office. Okay, the main office, the design registration office is in Chennai. Okay, next classification is the trade secrets. Okay, anything which is non-disclosing to the IPR, that is a very secret formulas, secret recipes, secret composition is covered under the trade secret. Like example is KFC, Coca-Cola. Okay, their formulas are protected under trade secrets. The geographical indication. So geographical indication is the basically the certain quality of the products is recognized with his originating. Okay, GI is indicating use of the identity of the products with its origin possesses the good quality and reputation that are due to its origin. The examples of the geographical indication is the Kolhapuri chappal, Darjeeling tea, Satara Kandi pede, okay, Tirupati ladu, Tirupati rice, Darjeeling tea, Nagpur orange, Kashmiri peta. Okay, these are some examples of the geographical indications like the Solapuri chappals. Okay, so what is the advantages of the geographical indication? Because of the geographical indications, the it helps to rural development, encourage the traditional knowledge. Also, the it helps to export the quality of the goods. Okay, so with the help of geographical indications, it's helpful to rural development. Next and very important uh, classification, IPR classification is the patent. Okay, in the patent, what is meant by patent? The definition of the patent is exclusive monopoly right granted by the government to his inventor. Okay, for his invention for limited period, that is the 20 year from the date of the filing of the patent application. It provides inventor rights to exclude others for making, using, selling, offering for sale, or importing the patented invention during the terms of the patent, that is the 20 years. Okay, after granting the patent holder can bought, sold, rent, hires that patent. Also patent with the help of the patent owner rights, he can mortgage the patent with the help of the patent values. Okay, so patent is a monopoly rights, monopoly because it exclude others for making, using, selling, and his products during the terms of the patent. So purpose of the patent system. Purpose of the patent: by virtue of the grant of the patent gets exclusive right in his favor of the prevent the third parties. Okay, it promote protection inventions. Okay, uh, and hence encourage the inventions. So this is the best example of the various IPR classifications covers under the single product. Okay, here this inhaler cover the four different types of the IPR classification. The name and logo is covered under the trademark. The composition of this inhaler formulation is covered under the patented formulation. Then design of this invention is covered under the design registration, and these logos and the concept is covered under the copyright. So this is the best example of various aspects of the IPR classification is covered under the single products. After that, we will see the what is patentable and what is non-patentable. The what is patentable criteria as per the Indian Patent Act. The patentable inventions, it should be new, novel. Okay, anything which is new, novel, and innovative, that comes under the patentable. After that, it should be non-obvious to the person skill in the art, or it should have some inventive steps. Okay, if anything which is new inventive steps in the present invention, that it covers under the trademark patent category. After the third one is it should have some industrial use. Okay, then and then only after accomplishing these three pillars, you will get the patent. Then what is mean by inventive step? Okay, inventive step is features of the invention which involve the technical advancement compared to the existing knowledge, economical significance with existing knowledge. Okay, it's having some surprising effect. Then and then only with existing knowledge, then and then only you will get the patent, which makes the invention it is non-obvious to the person skill in the art. Then and then only we can call it as a inventive step. So what is non-patentable? Okay, non-patentable as per the Indian Patent Act 1970, there are various exceptions are there that cannot be patented. Okay, the first one is the law of nature, physical phenomena, scientific principle is non-patentable. After that, any invention which causes serious disease to human, animal, or plant. Okay, any invention which is hazardous to plant, animal, or health, that is non-patentable. Method of agriculture and horticulture is also non-patentable because India is agriculture country. So method of agriculture and horticulture is non-patentable. Then mathematical and business method is also non-patentable. Plant and animal in a whole or part thereof is also non-patentable. Literacy, artistic work, dramatic, musical, this is also non-patentable in India, but we can protect it under copyright. Method of performing mental act and method of playing game is also non-patentable. Presentation of information is also non-patentable, but we can protect it under copyright. And traditional knowledge is also non-patentable, like various churnas, Grantokta formulations is also non-patentable in India. So these are the some exceptions that we cannot patent in India, but here the some concept is there that we can protect in out of the India. As per the pharma industry, there are four types of the patent applications. Okay, first one is the product patent. Okay, product patent means any new NC compound that we can call it as a product patent. Composition means any new compositions like nano suspensions or any technology-based composition is covered, that is covered under that we can call it as a composition patent. The process patent of method of manufacturing of that product or method of synthesis, that is covered under the process patent. Method of use means a method of claiming any indications or method of use of that product is called as a method of use. So types of patent applications. Once idea comes into your mind, you can immediately file the provisional application. The advantage of provisional application, you will get the priority date. Okay, in India, first to file is concept is there. So who one is first to file in Indian Patent Office, he will get the rights of the patent. So provisional application, if you are having no any data, you have just concept, then you can immediately file provisional application. So once idea comes to your mind, you can immediately file provisional application. After filing provisional application, you need to file complete application within 12 months. Okay, in complete application, you need to add a detailed scope of your invention in terms of the claims, abstract, detailed descriptions, background of inventions. All you have to write in a complete specification. After filing complete application, your patent application is published in Patent Office Journal. Then divisional application. Divisional application means the file in a plurality of invention. In India, one invention, one patent is there. So if your patent is plurality of invention, if your patent dual invention is there, then controller may ask you to file a divisional application, or you also voluntarily file the divisional application of the main application. After that, the patent of addition, minor modification and improvement is there in your main invention, then you can file the patent of addition. What is mean by cognate application? The cognate application means combination of two provisional applications, taking the priority of earlier patents. Okay, means merger of the two or three provisional application with in a single application. That is the cognate application. If you wanted to file your patent application in outside the India, there are two ways to file the patent application outside India. The first way is the conventional application. Conventional application means you need to file your patent application in individual country. If you wanted to file your patent application in US, Europe, Brazil, Australia, then you need to enter in that country. Uh, single country, you need to enter in that country and file your patent application. But there is another way is there, the PCT application. If you wanted to your file patent application through PCT, then centralized application is there. Through WIPO, you can file PCT application. With filing the PCT application, you will get time to enter in a national phase entry. Also, it designated to near about 157 countries. So at a time, you can enter to various countries, and you will get time to enter in a national phase entry. If you wanted to file conventional application, you need to file your patent application in individual country within 12 months. So this is disadvantage of the conventional application. Okay. So what is the patent filing procedure in India? Okay, once idea comes to your mind, you can immediately file provisional application. After filing provisional application, you need to submit your data in the form of Form 2 in a complete specification. After filing complete specification, your patent application get published in Patent Office Journal in two ways. One is the early publication, and second one is the normal publication. If you wanted to enter to early publication, you need to file Form 9 with additional fees. Okay, after filing Form 9, your patent application get published in Patent Office Journal within 3 months. But if you not file Form 9 or early publication form, your patent application get published in Patent Office Journal after 18 months. Okay, after publication, your you need to file request for examination in Form 18. Okay, there is another option is there, the express examination Form 18A. If you wanted to file your patent application through individual, then Form 18 fees 4,000. But if you wanted to express your examination, then you need to file Form 18A. The cost is 18,000 for individual startup and small scale enterprise. After filing request for examination, you will receive the first examination report. Okay, approximate time is 12 months, but it is not as per the Patent Act. Okay, after receiving the first examination report, you need to reply that first examination report within 6 months. Okay, if you fail to reply that first examination report within 6 months, then your patent application get abandoned. Okay, after first reply to first examination report, either your patent will be directly granted or controller may ask you for hearing. Okay, after hearing, your patent will be directly granted or refused. Okay, after refusing, if you wanted to file appeal, then you need to file appeal within 3 months to the High Court. Okay, so this is the standard procedure of the Indian Patent Office. But if you wanted, if anyone to file oppose that patent before the publication, before the grant, then it is called the pre-grant opposition. And after publication or after the grant of the patent, third party can oppose the patent after grant also. Okay, within 1 year of the grant. So this is the patent filing procedure in India. The which forms is required to patent filing the forms? The Form 1, 2, Form 3, Form 5, Form 26 is the mandatory form to file your patent application and get it published in Patent Office Journal. After publication, you need to file Form 18. Okay, after filing Form 18, then only your patent will be examined by the patent office. What is the fees for the filing of the patent application? The official fees for individual startups, small scale colleges, institute is the 1,600. After that, if you wanted to publish your patent application through for early publication, then Form 9 fees is the 2,500. Okay, so this is the fees for the filing of the patent application in India. So, what is the importance of the patent department in the pharmaceutical industry? Patent is the actually support system to the any innovative pharma company. That is, it helps to R&D department. There are various R&D departments in there, like synthetic means API R&D department is there, biotech is there, formulation R&D department here, and DTS department is there, various R&D department is there. So he supposed patent department supposed to support to the R&D departments to provide the patented, non-patented literatures. Okay, find providing the patent landscape, patent mappings. Okay, these are the some also providing the freedom to operate opinions. Okay, so also it support to the regulatory department. If anyone wanted to launch their product in India, US, Europe, or any country, then IP clearance is most important to launch their product in any country, domestic or international market. So for the regulatory department, IPR department plays a very important role. Also, it helps the marketing department, export department, medical services. Okay, so patent plays a very important role to in IPR department to providing a support and the providing the new projects to the R&D department. So, what is the responsibilities of the IP person in a pharma industry? It's support to the innovations. Whatever the R&D develop the products, so it uh, IPR department give protections to their inventions, finding the patentable inventions, drafting of the patents, then filing prosecutions of the patent applications in national or international market. Also, it supports to the product launch. It supports to the business development teams, providing in terms of providing the new projects. Okay, some expired patents, expired products, information of the expired patents, freedom to operate support, suggestive new way to R&D department to avoid patent infringement risks, prepare the patent litigation situations. Okay, support to R&D teams for future technology mapping, product suggestions, product landscaping. Okay, these are the some responsibilities of the IP person in a pharma industry. In a pharma industry, there are various department in IP department, like there are various sub department, like prosecution department is different, business development department is different, patent landscaping department is different, patent searching department is different. Along with that, the some synthetic group is different, formulation group is different, then biotech group is different. So various departments, sub department is also there in a patent department. Also, some IP trademark department is also different in pharma industry.
So, as we are going to talk about most funny and most weird patents, but before talking, I'll just want to remind my viewers, or just want to tell the new viewers, what is patent. See, patent is nothing. Patent कुछ नहीं है, एक legal document है जो आपको प्रोटेक्शन देता है आपके प्रोडक्ट, आपके प्रोसेस, आपके कंपोजिशन या आपके एपरेटस पे. ये एक कंट्री के पेटेंट ऑफिस आपको प्रोवाइड करता है, जिससे कि आप प्रोटेक्ट होते हो, आपका इंटेलेक्चुअल एसेट टेक्नोलॉजी प्रोटेक्ट करते हो, और आप स्टॉप कर सकते हो किसी और को अपनी टेक्नोलॉजी यूज करने से. So the first funniest patent which we'll be discussing today is banana case. US patent number is this. Around 132 years ago, 1888 में एक रेसिडेंट थे सेंट एंटेनियो टेक्सास RHAK, जिन्होंने पेटेंट किया बनाना केस. यस, यू हर्ड इट राइट, इट्स बनाना केस. मुझे समझ नहीं आता क्या इतनी जरूरत थी बनाना केस की, या क्या कहें. However, talking about the invention, this invention is to provide a case or carrot in which the banana may be readily packed and transported without injury to the fruit.
It consists of a body of cylindrical form made from one or more thickness of wire, the end of which firmly secured of two heads. So this was the invention detail. अगर आपको लगता है कि आपको इस केस की रिक्वायरमेंट है, so please इसको जरूर देखिएगा. Or at least to all the student innovators, if you can bring some modification, because this is very old invention and one of the funniest invention I found and thought to discuss with you, आपके साथ discuss करूं. So please अगर आपको लगता है आप इसमें कुछ improvement कर सकते हैं, तो bring something like this. So second patent.
रुको जरा, सबर करो.
It's about, actually the invention is about fart pad.
Music.
US patent number this. This was invented by Brian J. Konata and Myra M. Konata of US states, have patented an apparatus that helps to dampen fart and fart odor. The invention entitled Fartulence Deodomizer is an invention that discloses a pad to be worn by a person for absorbing gas due to flatulence. The inventor ने use किया charcoal cloth as a deodorizer because it is so much more effective in removing odor than any other agent. The deactivated charcoal cloth filter is also washable and reusable. This makes the present invention most effective, cost effective, comfortable, and least intrusive means of deodorizing gassy discharge. So this was one of the most funniest patent I have come across, but usable patent. The next is in the row, mustache guard, US patent number this. Around 135 years ago, 135 साल पहले 1890 में मिस्टर हॉलिंस हेड ने, अगेन ही इज फ्रॉम यूनाइटेड स्टेट, पेटेंट किया एक इन्वेंशन जो कि रिलेटेड है मुस्टैच गार्ड से. It was designed and adapted for use for suspending a gentleman's mustache in order to keep the same out of the way at the table, thus preventing the annoyance which is so frequently is experienced in eating soups and other foods, drinking tea, coffee, liquids by gentlemen having heavy mustache. Invention तो काम का है, but idea सी प्रॉब्लम आइडेंटिफाई किया. मैं खुद देखती हूँ कुछ लड़कों को, कुछ मेन को जिनकी बहुत हैवी मूछें हैं, वो चाय या कॉफी पीते हैं वो पूरा कलर हो जाता है मूछ. So it's actually a good, I would call it next is for all the beer lovers and for my team. Beer Bella. This patent was filed by Mason Scott, Flatbell, and Mark Andrew. This was filed in 2001 and patented in 2003. It's annoying when sun warms up your beer. I think yes. That's why there is a patent for a beer Bella, especially an umbrella that attaches to a bottle to shield it from sun. It also keeps out the rain if you are drinking outdoor in a shower. It's fun actually to make fun of patent that seems ridiculous, but it's sometimes a silly idea that can turn out to be successful. I salute all these inventors because they have taken the concept, they have identified the silly problem with a silly solution. That's why we are here sitting and discussing and also making fun. So here we come to the end of this video. I hope you have enjoyed it and you have also got an idea how to come up with idea identifying simple problems in the lives, which you can convert into intellectual asset, जिसको आप अपना intellectual asset बना सकते हो. एक छोटा सा problem आपको एक successful business भी खड़ा करने में help कर सकता है. So thank you very much. But before you
So not only all inventions have to be serious. Some of the most abused ideas have become a profitable business thanks to the IP protection. If you have a funny invention idea, you must just turn humor into the fortune. Okay. So up till now we have discussed the uh, IPR. Okay, what is IPR? The intellectual property rights. The intellectual property means we have discussed up till now the intellectual. Intellectual means creations of the things, come up with new ideas. Anything which is new, novel, that we will discuss. We have discussed. Also, we have discussed the IPR classification, include the patent, trademark, copyright, design, geographical indications, trade secrets. Okay, After that, we will discuss the patent filing procedure in India. Okay, we have now this is the technical part. Now, further we will discuss the actually uh, how to you will get enter in IP profession. Okay, so entering in the IPR field requires the combinations of the educational certification, internships, or networking. Okay, we will discuss step-by-step guide to starting your career in IPR. Okay, the very first point is the choose a right educational background. The educational requirement depends on your target role of the IPR. The very first is the if you are having a law background, LLB, LLM, the suitable for role like IP lawyers, trademark attorney, patent litigators. If you are a LLM in IPR, specialized diploma in IPR law, it's having the some added value to your educational. Then science or engineering graduation, MTech, BTech, M Pharmacy, B Pharmacy, okay, BSc, MSc, PhD. These are also suitable for the patent analyst, patent engineering, patent agents role. Ideal and industrial like pharmaceutical, biotech, IT, mechanical engineering. There you will get chance to enter. Also, if you are having a MBA background in IP management, business law, technology management, then suitable role like IPR manager, licensing expert, technology transfer officers. Okay, after that, if you are having a relevant degree like art, commerce degree, or can explore their role in copyright, trademark, branding, and publication rights. Okay, but the in patent department, commerce and art graduates are not having any role. Then gain of the IPR specific certification, like certification enhance your profile and increases job opportunity. Like patent agent exam is there. Every year patent office conducted the patent agent examination. For that, the eligibility criteria is the graduation of the any technical background. Then various WIPO courses is also available. There are various free and paid WIPO courses available on the WIPO Academy website. There are various PG diploma courses also in intellectual property, like projection diploma in IPR. It's offered by the NALSAR, NGO, okay, IIPTA, and various also universities also providing the post-graduation diploma in IPR. Then copyright and trademark courses is also available. Some certification courses is offered by the various law institute, universities. Online platforms is also available, like Coursera, Udemy, etc. Various courses also available, certification courses also available. Then gain practical experience through internship. Okay, if you want real experience, then join any IP firm or any industry in IPR department. Okay, internship which helps in gaining industry exposure, building connections. Okay, apply to any law firm specialized in IPR, like various firms are there, like Anand KN Partner, Kurana and Kurana, IP Intellect Services. Various firms are there that can provide you the internship. Also, the corporate IP department is there, like TCS, Infosys, Biotech, then Biocon, Dr. Reddy, Ciplas, various firms. Corporate IP department is there that also you can apply there. Government organizations is there, like Indian Patent Office, Corporate Office, CSIR Labs is also available. Okay, some incubation centers is also available. Then startup and research institute also there, like IIT, NIPOS, NALSAS, etc. That also provide you the internship. Also, you can find internship on LinkedIn, uh, then various company website, intershalas, various websites is also available for the internship. Then build key steps, key skill for your IPR job. To stand out the IPR role, to develop like legal and analytical skill, understanding the patent, trademark, copyright, geographical indication. Then technical knowledge is also required, like the Patent Act related information, required patent related rules. Okay, then drafting and documentation skill is required. The patent writing patent application and legal notices is also important. Research and attention to details like crucial for the patent searching, IP litigations. Then communication and negotiation skills is also required, useful to client interpretation and IP licensing. The communication negotiation skills is also required. Then next point is the where to apply the IPR jobs. Okay, various job portals are available like Naukri, LinkedIn, Indeed. Okay, IPR careers. Various company website is also there. They can check the company IP law firms, tech companies, the pharma firms is also there. Some also the some government job is also there, like Indian patent. If you see the Indian patent office website, CSIR website, DRDO website, there are also some government job is also there. For the entry level job role in IPR, like the patent analyst for the science and engineering graduate is required, trademark associate, any law graduate is required, IP executive assistants for the MBA commerce graduations is required. Research associate IPR, like academic research and research institute also there. Okay, so also you can enhance to join various networking and join professional associations. With the help of that, you will also get the knowledge of the IPR, like join IP organizations like INTA, WIPO, AP, APA, then FASI IPR. Okay, the various IP organizations is there. Like also attend the IP seminars, webinars. Okay, which is conducted by WIPO, FASI, law firms, and various colleges also organize various seminars, webinars. That also you can join. Then LinkedIn and law forums is also there. Like the connect with IPR professionals and seek memberships of various IPS associations is there, that we can that also helps you to entry in IPR department. So to enter in IPR field, the very first is to get a relevant degree in law, science, or MBA. Okay, that is mandatory to all. After, if you are having degree, then at least one IPR certification is there, or you can clear the patent agent examination or post graduation diploma or join some WIPO courses. After that, if you get chance to get internship in a law firm, corporate research institute, that is also better for your career. To develop key skill in the patent drafting, legal research, IP strategy, that is also very much important. Apply job for to LinkedIn, law firms, or some government organizations. Okay, also join the some network with professions of the IP law forums is there. So take various memberships of the IP law firms. So these are the some points that with the help of that you can get entry in IPR professions. So various courses also we discuss, like the post-graduation diploma the courses is available in patent law, like NALSAR is providing. Okay, National Law School of Indira University Bangalore is also provided. Okay, Indira Gandhi National Open University is also providing the post-graduation diploma in IPR. Also, there's some government organizations like patent offices also conducted the patent agent examination. The details of the patent examination we will see in further slide. Also, the some law colleges will also offer some certification course, post-graduation diploma, or you can join after completion of BPharm. You can join the LLB also. That is also important for you to do career in IPR. So, what is the requirement of the patent agent examinations? Okay, as Indian Patent Office every year conducted the patent agent examination. For that, the some eligibility criteria is there. That is the person, he is the citizen of India, and his age completed age of 21 year. Then he obtained the degree in science, engineering, or any technology from the Indian university. Okay, then he passed the patent agent examination, which is conducted by the Indian Patent Office. After that, he will be a patent agent. So who conduct the patent agent exam is the Indian Patent Office, actually the Controller General and the Patent of Trademark under Section 126 of the Patent Act. Every year conducted the patent agent examinations. Normally the forms released in the month of the August and September, and exam will be conducted in the month of January. Okay, so every year the patent agent examination will be declared by the patent office. So all the graduate student can appear for the patent agent examination. The various centers are there, like Mumbai, Chennai, Delhi, Kolkata, Nagpur is there. So what is the pattern of the patent agent examination? There are two papers are there: paper one, paper two, and Viva was. Okay, paper one is the 100 marks, paper two is 100 marks, and Viva is the 50 marks. Paper one is the multiple choice questions. Okay, 100 questions are there. Each questions carries 1 marks. Okay, out of 100, no negative marking system is there. So within 3 hours, you need to 3 hours paper is there, multiple choice questions, paper one, and the 50% passing is there. Out of 100, you need at least uh, you have a 50 marks out of 100. Paper two is the case studies and the drafting part is there. Okay, so out of 250, at least you need to qualify the patent agent at least 150 marks. So 60% passing is 60% uh, passing is there. So, what is the role of the patent agent examination? The practice with the patent office in India. Okay, prepare all document, transit, and discharge all functions in connections with the any proceeding with the patent office relating to the patent applications. Eligible to apply for the patent, obtaining the patents in India or elsewhere in India. So authorized to prepare the specific of the patents, other documentations related to the patent prosecution, authorized to provide the opinions, the validity of the patents, patentability opinion, infringement opinion, patent landscaping, patent mapping. Various roles are there as a patent agent. So also government is taking more initiative to encourage the IPR. So encourage to startup to protect their innovations, appointing the patent facilitators. Okay, reductions in the fees, filing fees for the startup MSME, expedite the examination process for the startup individuals. Okay, Make in India programs also various campaigns is providing various awareness programs is also conducting the patent office every year, increasing the global presence to strengthen the patent regimen specifically for the pharma industry. So government is also taking more initiative to encourage the IPR. So basically, how to build your career in IPR? The very important part is the educational and skill is more important. At least you have a science graduation is required. After that, if you are having additional LLB, LLBM, that is more important. If you are having some post-graduation diploma, is also added benefit to enter in IPR department. If you are having MBA with IPR specialization, suitable for the IPR strategy, commercialization, management rules, is also more important. Certifications also, exams is also there, like patent office, patent agent examination, patent examiner examination is also there. WIPO certifications is also providing. Okay, some post graduation diploma is also providing by some institute also. Also getting internship, IPR conferences, workshop, IP forums, associations is also very much important to enter in IPR department. So demand of the IPR professional is increasing across the industries due to the technical advancements and the global awareness, whether in law, corporate strategy, research, and the freelancing of the IPR offers, rewarding the career opportunity for those with the right expertise. Okay, so as per the career opportunity concern, the various industries can provide you the job role in a pharma industry. Okay, not only the pharma industry, you will get chance to enter in any industry uh, to get career. Okay, opportunity to work in core or pharma companies in their in-house patent teams is there. Okay, every innovator company having the uh, some IP department is there. The IP department also sub department is there. There, like I have already discussed that the uh, some patent searching department is there, patent prosecution, patent freedom to operating, patent landscaping, business development, IP department, various sub department is there in an innovator company. Like companies, you will get chance to enter in Novartis, Pfizer, AstraZeneca, BMS. These are also innovator company. You will get chance to enter in this company. I have mentioned some few of companies of pharma industry. So opportunity to work with some generic pharmaceutical companies like Sun Pharma is there, Dr. Reddy, Lupin, Glenmark, Zydus, Cipla. Various companies are available there. You will get chance to enter. Also, not only pharma company. After you are having some knowledge of the IPR, if you are a patent agent, then you will get chance to enter in a electronic and communication industry also. Okay, as a pharma graduation, you work in a Samsung, LG, Sony, Apple, Dell, HP. Okay, you will get chance to enter in this department also if you are having some knowledge of the IPR, you are having some certification of the IPR, or you are having some qualifications of the like patent agent, trademark agent. Then you will get chance to enter in electronic and communication industry also. Also, you will get chance to enter in a software and other services like IBM, Uber, Google, Facebook, Amazon. Okay, these are some few software company I have mentioned here. So these companies also you will get chance to enter. Also, you will get chance to enter in a mechanical automobile industries like Ford, Mercedes, okay, Toyotas, okay, these Skoda companies, okay, these are the some mechanical automobile industry also you will get chance to enter. Also, you are having career opportunity with various services and consultation companies like Evolsons, okay, United Lakes, then Grey TT consultancies. Okay, these are the some consultancies services there where you can apply. Okay, opportunity to work with a law firm specialist in IP services like IP Intelligence Services and then Lex Orbis, KNS Partners. Various IP firms are there. There you will get chance to enter. Also, opportunity to work with the database software companies like the Claravis, okay, CAS, SciFinders, IPT Analytics, okay, various database providing companies also gives you the job opportunity. So career opportunity to work with the Indian Patent Office also. As a central government, there are various job opportunity also available. Indian Patent Office conduct an exam to select the examiners also, but not frequently. But some notifications is also there. You can check on Indian Patent Office site. Exam is purely technical based. Okay, you can start your own company, okay, like IP Intellect Services, like KNS Partners, like Service, or you can after completion of patent agent examination, or you appearing you are successfully completed the patent agent, then you will start your own company. Service based industry also, you will get chance patent searching. You can work as a freelancers. You can work in a law firm specialist in IP services, okay, patent drafting, filing, some court matter is there, then patent landscaping, various opportunities there. So career option as a patent agent or patent attorney, you become an advisor to various institute, R&D centers, various companies. Okay, join as a law firm as a consultant, IP consultant, work as a drafting specialist. Okay, also you can join as a IP manager and corporate IP specialist in a R&D department. Join as a IP coordinator to various institute, R&D centers, various companies. Okay, also you can independently practice as an IP law firm. Also you can join as a LPOs, KPOs, join as a technology transfer managers. Also you can join as academicians to as a guest lecturers or the full-time lecturers in various law colleges, IP universities. Okay, join as a patent examiner or patent analyst in an Indian patent office. So various opportunities there. Also you will get chance to enter in a pharma chemical industries. Okay, as a B farm basis you will get chance to enter in pharma industry, but not only pharma industry. If you are having IPR knowledge, then you will get chance to enter in the information technology companies, biotech companies, automobile countries, electronics, electrical industries, navigation, space research based universities. N numbers of opportunities there, like defense services also, DRDO, DRDL, and other defense wings is there. That there also you will get chance to enter. Also you will get chance to enter in agriculture, feed industry, fertilizer industry, various IP facility centers like TIFAC, GENAC. Okay, various these facility centers, incubation centers are there where you can apply for the patent analyst. Legal outsourcing companies, knowledge outsourcing companies, law firms, corporate law firms, patent searching organizations is also there. Some government institute like CSIR, UDIP is there. They are providing near about 100 to 200 people every year. Okay, international bodies like WIPOs and other UN bodies also there. Some patent office also, some contract basis posts are also available. So various fields are there. So various institutes also there where you can apply for a patent agent.
हेलो फ्रेंड्स, वेलकम टू लॉ सीखो। आज की वीडियो में मैं आपको एक फेमस केस स्टडी के बारे में बताने वाला हूं। देखिए, ओरियो पार्ले के बीच में डिस्प्यूट हुआ था एक बिस्कुट को लेके। क्या ये डिस्प्यूट था, क्या इस केस के फैक्ट्स है, सारी इंफॉर्मेशन आपको इस वीडियो के अंदर देने वाला हूं। बहुत इंपॉर्टेंट वीडियो है, पूरी एंड तक देख के जाना। देखिए, ओरियो एक बहुत फेमस ब्रांड है, पूरे वर्ल्ड में इसको लोग जानते हैं। आपने भी शायद इसका बिस्कुट तो डेफिनेटली खाया होगा। 10 साल से भी ज्यादा पुरानी ब्रांड है इंडिया के अंदर। बिस्कुट को सेल कर रही है। अब यहाँ पे दिक्कत क्या हुई, जो ओरियो का बिस्कुट था ना वो बहुत पॉपुलर था, पार्ले वालों ने क्या करा, थोड़ा सा देख लेते हैं, कॉपी कर लेते हैं। पार्ले वाले के डिजाइनर ने थोड़ा बिस्कुट को कॉपी करा, पैकेजिंग को कॉपी करा और खुद की एक मार्केट के अंदर ब्रांड लॉन्च कर दी फेबियो नाम से। अब ओरियो ने पार्ले के ऊपर केस फाइल कर दिया कि आपने हमारा पूरा आईपीआर कॉपी करा है, फ्रॉम ट्रेडमार्क्स टू डिजाइन रजिस्ट्रेशन एंड कॉपीराइट्स। अब मैं आपको बताने वाला हूं कि क्या क्या इश्यूज इन दोनों के बीच में थे एंड कहां कहां पे पार्ले गलत था। देखिए, सबसे पहले बात करते हैं ट्रेडमार्क की। सामने वाली पार्टी का नाम है एक ओरियो और दूसरे वाले का नाम है फेबियो। अब दोनों के नेम तो अलग अलग है, नेम बिल्कुल भी ज्यादा मिलते जुलते नहीं है। दूसरी चीज, अब डिजाइनिंग को देखते हैं। जो आपको डिजाइन दिख रहे हो ना कवर पे, पूरा ए टू जेड कॉपी करा गया, मतलब 99%। अगर आप देखो तो कलर स्कीम से लेकर सब कुछ कॉपी कर दिया इन्होंने, कलर भी सेम रखा है। फिर उसके बाद आता है डिजाइन रजिस्ट्रेशन। अब डिजाइन रजिस्ट्रेशन में क्या है, जो ओरियो का बिस्कुट देख रहे हो ना उसका एक स्पेसिफिक डिजाइन है। ये करते हैं सैंडविच की तरह अपने बिस्कुट को बनाते हैं, नीचे ब्लैक कलर का, बीच में क्रीम लगाते हैं व्हाइट, फिर उसके ऊपर वापस ब्लैक कलर का बिस्कुट लगा देते हैं, उसके ऊपर वो डिजाइन बना हुआ होता है। अब फेबियो में भी सेम डिजाइन बना हुआ है, सेम तरह का बिस्कुट है, तो इसको बोलते हैं डिजाइन रजिस्ट्रेशन। इसकी प्रोटेक्शन 10 साल तक के लिए मिलती है, प्लस 5 इयर्स के लिए आप एडिशनल प्रोटेक्शन को बढ़ा सकते हैं, कुछ गवर्नमेंट फीस आपको जमा करानी पड़ती है, तो टोटल 15 इयर्स के लिए आप अपने डिजाइन के ऊपर प्रोटेक्शन क्लेम कर सकते हैं। अब पार्ले ने जो फेबियो ब्रांड है उसको भी कॉपी कर डाला, तो यहाँ पे इन्होंने डिजाइन रजिस्ट्रेशन को भी कॉपी करा। उसके बाद अब यहाँ पे अगर ओरियो के पास जो रेसिपी है ना उसका अगर पेटेंट रजिस्ट्रेशन है इंडिया के अंदर, तो वहां पे भी फेबियो गलत है। अगर उसने उसका पेटेंट की रेसिपी को भी कॉपी कर डाला हो तो वहां पे भी एक केस पॉइंट उठ सकता है। अब हम आगे बात करते हैं। देखिए, अब मैं बात करूंगा ट्रेड ड्रेस की। ट्रेड ड्रेस क्या है, देखिए क्या होता है, जब भी हम कोई ब्रांड मार्केट से उठाते हैं ना, बड़ी ब्रांड्स क्या करती है, बहुत तरीके से मार्केटिंग करती है, अच्छे तरीके से मार्केटिंग करती है, अलग यूनिक शेप लेकर आती है, कलर लेकर आती है, कुछ स्कीम्स लेकर आते हैं, जिससे वो ब्रांड आपके माइंड में रजिस्टर्ड हो जाए। मैं सिंपल तरीकों में बताता हूँ आपको। आप है ना अपनी आंखें बंद करो और फरारी के बारे में सोचो। रेड कलर की फरारी डेफिनेटली आपके मन में आई होगी। क्यों? क्योंकि हमें जब भी फरारी दिखती है हमेशा रेड कलर के अंदर दिखती है, एंड जो फरारी के ओनर्स हैं, मालिक है मेन कंपनी के, उन्होंने ब्रांड को मार्केटिंग में ऐसे करा है कि रेड कलर से। पहली चीज। दूसरी चीज, अब कुछ ह्यूमन पर्सनैलिटीज की बात करते हैं। आप अपने मन के अंदर नरेंद्र मोदी जी की इमेज को सोचो, आपको डेफिनेटली जो इमेज आपने मन में सोची होगी ना उसके अंदर कुर्ते पजामे के अंदर होंगे, तो वो पॉलिटिशियन है, इंडिया के पीएम है, आपको जीन्स में नहीं सोचा होगा आपने, तो उनकी एक पर्टिकुलर तरह की ड्रेस है। अब बात करते हैं गुड्स और सर्विसेज की भी, तो आप पार्ले को सोचो। जैसे ही मैं पार्ले जी बोलूंगा ना और आपको बाजार के अंदर छोड़ दूंगा कि मुझे पार्ले जी का बिस्कुट ला के दो, बट उस बिस्कुट के ऊपर अगर आप पार्ले जी भी हटा दो ना, उसका नाम ब्रांड नेम भी हटा दो, फिर भी आप पहचान जाओगे कि पार्ले जी का बिस्कुट है। क्यों? उसकी कलर स्कीम को देख के, वो लड़की की फोटो देख के, उसके बाद जो बिस्कुट के डिजाइन है रेक्टेंगल के अंदर, इसको बोलते हैं ट्रेड ड्रेस। मतलब उसका तरीका क्या है जो हमेशा एक तरह कॉमन होता है। इसलिए ब्रांड्स बहुत ज्यादा पैसा खर्च करती है कि ह्यूमन पैटर्न्स को डेवलप करते हैं। ह्यूमन पैटर्न्स क्या होते हैं, लेट सपोज मैं बाजार के अंदर जाऊंगा तो बार बार मेरा हाथ पार्ले जी के उन बिस्कुट्स के ऊपर जाएगा, भले ही मैंने पढ़ा भी नहीं होगा उस पार्ले जी पे कि उस पैकेट पे पार्ले जी लिखा हुआ है या नहीं लिखा हुआ है। एक रिजेंबलिंग मेरे माइंड में क्रिएट कर दी गई ब्रांड के द्वारा। वैसे ही ओरियो के साथ होता है, जो उनका ब्लू कलर का है ना, अगर मैंने ओरियो नाम लिया है ओरियो बिस्कुट, तो मन में यही आएगा कि ब्लू कलर की पैकेजिंग है, गोल बिस्कुट है और सैंडविच जैसे। अब यहाँ पे उन्होंने ट्रेड ड्रेस का भी एक वायलेशन कर दिया, पार्ले वालों ने पूरी तरीके से उन्होंने कॉपी कर दिया। अगर आप डिजाइनिंग से देखें, सब कुछ देखें, कलर से लेके, डिजाइन से लेके, प्रोसेस से लेके, सब चीजों को उन्होंने कॉपी कर डाला। अब मैं आपके लिए यहाँ पे क्वेश्चन छोड़ता हूँ। देखिए, अगर आप लोग किसी भी ब्रांड को कॉपी करते हैं जो इंटरनेशनल ब्रांड इंडिया के अंदर अभी तक नहीं आई है, यूएस में बैठी हुई, यूके में बैठी हुई, बहुत फेमस है, बहुत अच्छी चल रही है, उस ब्रांड को आपने इंडिया के अंदर कॉपी कर लिया, तो क्या वो ब्रांड इंडिया के अंदर आके आपके ऊपर केस फाइल कर सकती है या नहीं कर सकती है? इसका आंसर
Okay, so IP protection is the powerful tool to help the small startup also attract some fundings, partnership firms to build strong brand identity. Okay, this is the conclusion of this video. So anyone having questions? Any questions, please?
If audience having any question, please ask questions without hesitation. Audience, type questions into the chat box. Okay, so I got some questions. And the first is, how long does patent protection last, sir?
20
How long
years
does?
date of the filing.
Okay, 20 years
Yeah,
from the filing.
from date of the filing. Yes.
Okay, sir. Okay, thank you, sir. And also one question more: is a patent valid in every country, sir?
Patent is valid in every country.
Country or not?
Sorry.
Patent is valid in every country or say,
No. Patent is a territorial rights. Okay, if you get patent in India, then you will rights is only limited to the India. If you wanted
okay,
to
sir.
protect your right in out of the India, suppose US, Europe, then you need to file your patent in that country. Okay.
Okay, sir. Okay. Okay, thank you, sir. Any other question from audience? Okay, thank you. Thank you, sir, for such insightful presentation and for sharing your valuable guidance with us. Your expertise and time are truly appreciated, sir. I hope all attendees will utilize this knowledge in their future endeavors. So, thank you, sir, for giving such beautiful and knowledgeable information to our all audience. So, once again, thank you, sir.
Okay. Thank you.
Before moving towards second session, we will take a 5 minute gap, and after that, we'll start our next session. So all audience remains all audience be online.
Hello, hello, hello.
Yes, ma'am.
असं करू का? ओके. दिसतंय. मी नंतर चालू करते आता.
Hello.
Hello, ma'am.
Yeah, yes, Sharma ma'am, are you ready?
Yes, ma'am.
Okay, ma'am. Before moving toward the second session, uh, so welcome into the second session, all audience. I think 5 minutes are covered, so we will start our second session. Firstly, I welcome Ms. Ankita Sharma ma'am into the one-day seminar of patenting in pharmaceuticals, challenges and case studies. So, welcome ma'am. Ankita Sharma ma'am is currently working as an IP manager at Mprex Private Limited, Pune. She has completed her M.Pharmacy in Pharmacology from Savitribai Phule University, Pune. She has extensive experience in filing patents, trademarks, copyrights, and design patents. Additionally, she has worked in pharmaceutical research and innovations protection. We are fortunate to have such a knowledgeable and dynamic speaker with us today. So, I request Ms. Ankita Sharma ma'am to kindly begin her session. So, ma'am, please start your session.
Is my voice audible?
Yes, ma'am.
Yes. Thank you for the brief introduction. So, shall we start with the presentation?
Yes, ma'am. Start.
Okay. Yeah. So, let me share my screen. Is my screen visible to all of you?
Yes, ma'am. Yes.
Okay. So, good morning, all of you. In today's session, we will cover the points such as patentability criteria in pharmaceutical industry and compulsory license. Okay, with the case studies. So Mahesh sir has already discussed about the IPR and IPR types. IPR means what? Intellectual property rights and the types in which included patent, trademark, copyright, trade secret, and design. Indian patent design. Okay, so let's start with the introduction to patentability. So, the pharmaceutical industry discovers, develops, produces and markets drug or pharmaceutical drugs for use as a medicine. The pharmaceutical companies may deal with generic and brand medications and medical devices. They are subject to a variety of laws and regulation that govern protecting, testing, safety, efficacy, and marketing drugs. Okay, so the main goal of pharmaceutical industry is to provide drugs that prevent infection, maintain health, and cure diseases. The industry directly affects the global population, so as number of international regulatory bodies such as WHO, World Health Organization, and
हेलो
MHRA.
हेलो
Yes, ma'am.
मैम प्लीज़ आपकी जो स्लाइड है वो व्यू मोड पर ले लो ना.
Yes, ma'am. Okay.
ओके.
Now this slide is visible.
यस मैम. यस.
Okay. Okay, so the patentability is the legal requirement that an invention must meet to be eligible for the patent, and it refers to the set of criteria such as novelty, inventive step, industrial applicability, and patentable subject matter that determine whether an invention can be granted patent protection under the applicable laws. Okay, so the industry directly affects the global population. So the next point is role of IPR in pharmaceutical industry. IPR means intellectual property rights. Okay, so the pharmaceutical industry is one of the evergreen industries in the world, no matter whatever happens. Okay, whether the economy is on most stable behavior or in recession mode. Okay, any day a person can fall sick or might require his supplement pills. Okay, so basically the pharmaceutical products are used 24 into 7. So what are the types of IPR which are involved in pharmaceutical industry? The first one is patent protection. Okay, pharmaceutical rely heavily on the patent to protect their invention, including new chemical entities, formulation, and manufacturing processes. Okay, then next is innovation and incentive. Okay, IPR encourages innovation by providing exclusive rights to inventors, allowing them to recoup investment in research and development. Competitive advantage: the patent protected drugs can be command on premium prices, which giving companies a competitive edge in the market. Then industrial design or regulatory compliance. IPR influences the regulatory framework, ensuring the pharmaceutical companies comply with safety and efficacy matters. Okay, so these are the various types which are involved in pharmaceutical industry, types of IPRs. Okay, the next point is evolution of pharmaceutical industries. Indian pharmaceutical industry has come a long way from being non-existent to being one of the largest and most advanced industries in the world. Its evolution can be divided into this stage: ancient civilization. In ancient civilization, there were the traditional medicines were used for the various diseases. Okay, then in middle ages, the monks developed and dispensed the medicinal remedies. Okay, then industrialization, emergence of pharmacies. Independent pharmacies replace various herbal therapies. Then in modern era, discovery of various antibiotics, vaccines, okay, like penicillin and other antibiotics, revolutions in infection disease treatment, and vaccines for the disease like polio and measles were introduced during the modern era. And contemporary era, the digital health, the technology and analytics are transforming the pharmaceutical research and development, clinical trials, and patient engagement. The globalization, the industry has become the increasing global with multinational companies and international collaborations. Okay, so this is regarding evaluation of pharmaceutical industries. Then what is patent? As I have said, the Mahesh sir already told what is patent, trademark, trade secret, design patent. Okay, so I'll brief this what is patent. Okay, a patent is a form of intellectual property that gives its owner the legal right to exclude others' form of making, using, selling an invention which may be or which can be product or a process for a limited period of time, that is 20 years, in exchange for publishing and enabling public disclosure of invention. Okay, so the requirement for patentability criteria. Okay, first one is novelty. The invention must be new or obvious to the authors in the same field. The section 2(1)(j) is included in the novelty for the Patent Act in 1970. Okay, so the section 2(1)(a), what says the section 2(1)(a)? The inventive step or the novelty means a feature of an invention that involves technical advance as compared to the existing knowledge or having the economic significance, or both, that makes the invention non-obvious or novel or new to a person skilled in an art. Okay, in simple terms, it provides a technical advantage over existing solution or has economic significance or non-obvious to this to a person who is expertise in the relevant field. Okay, then inventive step. The section 2(1)(ja) is included as a inventive step in the Patent Act 1970. Okay, so the inventive step is an invention or a technology which has not been anticipated by the publication or any document which is used in the country or elsewhere in the world before the date of filing the patent application with the complete specification, that is the subject matter has not fallen in public domain or that it does not form the part of state of an art. Okay, it means the inventive step has not been publicly disclosed or published before the patent application filing date or has not been used in India or elsewhere in the world before the patent application filing date. Then written description. The section 10 is included in the Patent Act 1970 is all about the written description. Okay, so every complete specification shall fully and particularly describe the invention and its operation or use, or disclose the best method performing the invention which is known to the applicant, for which he is entitled to the claim protection, or the complete specification end with the claim or claim defining the scope of the invention for which the protection is claimed. Then disclosure based method. The section 10 4b is included in Patent Act 1970, which is all about the disclose based method. Okay, so it fully describes the invention or its operation, or it also discloses the best method performing the invention. It also includes the claims that define the scope of the invention. Okay, so this is all about the requirement for the patentability criteria. Then next point is types of pharmaceutical patents in India. There are various types of pharmaceutical patents in India, in which first one is drug compound patent. Here, the drug compound patent include the drug compound by chemical structure. Okay. Then second one is formulation and composition patents. Here, this patents claims as a specific technology to prepare a formulation and a quantity of its ingredients. Then third one is synergistic combination. Okay, this patent claims that the drug in combination produces a synergistic effect. Okay, synergistic effect with each other. Then fourth one is technology related patents. These patents are based on the techniques to solve the specific technology. So this is about types of pharmaceutical patents in India. Then next point is evergreening of pharmaceutical patent. What is meant by evergreening? Evergreening is the strategy used by the pharmaceutical companies to extend the patent life of a drug to maintain the monopoly in the market. Okay, evergreening is defined in the different ways wherein the patent owners take undue advantage of the law and associated regulatory processes to extend their IP monopoly, particularly over high blockbuster drugs by filing the patents on an already patent protected invention shortly before the expiry of the parent patent. Okay, so companies make minor changes in the drug formulations which may or may not be increase the efficacy of the drug, and then they try to get an extension on their existing patent. However, this process is hardly ever mentioned in patent protection cases. Okay, so there are various types for the evergreening of pharmaceutical patents. It by making the minor modification to an existing patented drug. First one is changing the dosage form. It means, for example, from tablet to capsule form. Okay, then next one is modifying the formulation. For example, adding a new excipient to the main formulation, okay, or a parent formulation, then developing a new indication or a use of that drug, then creating a combination product with the another drug for providing the synergistic effect. Okay, so this is the case of Novartis and Union of India, which will be discussed after some time. Firstly, section 3 in the Patent Act 1970. Okay, to avoid the evergreening of pharmaceutical patents, section 3D in the Patent Act were developed. Okay, so the section 3D in the Patent Act 1970 is the key provision that prevents the evergreening of patent or ensures that only the truly innovations or innovative inventions get patent protection in India. Okay, for example, if a company is already has a patent on paracetamol drug, they cannot get a new patent just by changing its shape, color, or formulation, like making it is in gel form. Okay, unless they prove that the new form works better than the old one. Okay, so it needs to be formed in new efficacy. Okay, so the case of Novartis versus Union of India is the landmark judgment by the Supreme Court of India for the evergreening of pharmaceutical patent. Okay, so Novartis is a Swiss pharmaceutical company developed a cancer treatment drug called Glivec in 1997. In 1997 filed a patent application, but it was rejected by the Indian Patent Office in 2006 because the main issue is that the Glivec was a slightly different version of their 1993 patent for anti-leukemia drug. Okay, so so the Glivec was not a new invention, but rather a new form of an existing substance or a drug of anti-leukemia drug, that is imatinib. Okay, Novartis failed to demonstrate the significantly improved efficacy for Glivec compared to the imatinib. So the Supreme Court upheld the decision of Calcutta High Court and Patent Office and rejected the patent application. Okay, so this is the example of evergreening of pharmaceutical patent. This is all about the patentability criteria and evergreening of pharmaceutical patent. Now the next point is compulsory licensing and its impact on the industrial in the Indian pharma industry. Okay, so what is we will cover the points such as compulsory license, case of Natco versus beer, and the solutions for the future. Okay, so what is compulsory license? So a compulsory license is a permission given by the government to someone other than the patent holder to manufacture, sell a patented product without the patent owner's consent under the specific condition. It means it is a government issued authorization which allows third party to produce, sell a patented product or use of patented process without their consent. Okay, without the consent of their patent holder. Okay, compulsory license are typically issued to address the public health concerns, promote the competition or support the national emergencies. Okay, so there are various grounds for the compulsory license. First one is public health, to ensure the access to essential medicines, particularly for the disease like HIV, AIDS, TB or malaria. Then next one is anti-competitive practices. Here, to prevent the patent holders from engaging in anti-competitive behavior such as refusing to license their patents. Then third one is national emergency. Okay, to address the national emergency such as pandemic or a national disaster. And last point is dependence on a patent, to allow the use of patented invention that is necessary for the production or operation of another invention. Okay, so why it is given, why the compulsory license is given? Okay, when a patented product like a medicine or a drug is too expensive or not available to the public at the reasonable price. Okay, if the patent holder is not making enough product to meet the public demand, or in cases of the national emergencies, public health crisis or urgent needs during the pandemic. For example, imagine a life-saving cancer drug is patented and too costly for the most of the people. If the patient owner refuses to lower the price or supply enough, the Indian government can grant a compulsory license to another company or a third party to produce or sell the drug at a lower cost to make it more accessible or more available. Okay, so the original patent holder still gets royalties or a payment. Royalties means payment for the drug, for that invention, but they cannot stop the production for the licensed version. Okay, then Indian issued its first compulsory license in 2012. Okay, we'll discuss this later. Then what is voluntary and compulsory license, or the difference between voluntary and compulsory license? So voluntary license is an agreement between the patent holder and third party where the patent holder grants permission to use their patented invention in exchange for the royalties and other forms of compensation. Okay, so there are various key features of the voluntary license. Here first one is mutual agreement. Okay, both parties agrees to the term of the license, they negotiated terms. Okay, like royalties, duration and other terms are negotiated between both the parties. And flexibility, voluntary license can be tailored to meet the specific needs of the patient. It is called as voluntary license. Okay, voluntary license and compulsory license are the two different types of licenses which allows the third party to use a patented invention. Okay, but voluntary license means it voluntary the patent holder gives permission to use the license, use the drug. Okay, and compulsory license, as I said earlier, a compulsory license is a government issued authorization that allows the third party to use the patented invention without the consent of the patent holder. There are various key features of the compulsory license. First is government issued, the license is granted by the government authority. Then compulsory license is also called as non-voluntary license. So because the patent holder does not agree to give or to use the license. Okay, and the terms of that license including royalties, payment are determined by the government authority. Okay, so the procedure for granting the compulsory license, there is a procedure for granting the compulsory license. Okay, a third party applies for a compulsory license to the relevant authority. Okay, it means the third party needs to apply for an application to use the compulsory license for the drug. Okay, then the patent holder is given an opportunity to be heard. Okay, to be heard in the court. Then the authority decides whether to grant the compulsory license to the third party or not. Okay, and the authority sets the terms and conditions of the license, including royalties. Okay, if the court is allow the third party to use the compulsory license or use the drug. Okay, so this is about voluntary and compulsory license. The next point is legal provisions of compulsory license. Okay, the legal provisions for compulsory license vary by jurisdiction, but here are some general principles and provisions found in various laws. Okay, here first one is Paris Convention, then second one is under TRIPS agreement, then third one is under Indian national legislations. Okay, we'll discuss one by one. The first one is under the Paris Convention 1883. Okay, so the Paris Convention for the Protection of Industrial Property in 1883 is an international treaty that sets basic rules for the patent, trademark, and industrial design in member countries. Okay, according to the Article 5A2 of the Paris Convention, allows member countries to grant the compulsory license for the patent under the certain conditions. That is, the first one is failure to work the invention. The patent holder must have failed to work the patent invention the country within the reasonable time, usually 3 to 4 years. Then insufficient supply. The patent holder must have failed to meet the demand for the patented product in the country. Then third one is public interest. Okay, the compulsory license must be granted to address a public interest such as public health or national security. Okay, so as per the Article 5A2, the compulsory license must be non-exclusive. It means the patent holder may still use the invention. Then non-transferable, must be non-transferable. The company license cannot be transferred to the another party or another company, and it is in limited in scope. The compulsory license limited to the specific purpose for which it was granted. For example, if a company patent is a life-saving drug but does not manufacture or sell it is in country, that means the country can issue compulsory license to the another company to produce or sell the drug as an to an affordable price. Okay, so next one is under the TRIPS agreement, the compulsory licensing under the TRIPS agreement 1995. The TRIPS agreement, what is meant by TRIPS? TRIPS, the trade related aspects of the intellectual property rights. Okay, so the TRIPS agreement sets a global rules for patent, trademark, and copyright, which allows the compulsory licensing under the certain conditions to balance their patent rights with public interest. Okay, so there are various key TRIPS provisions on compulsory licensing. Okay, as per the Article 30, which provides the limited exceptions to the rights conferred under the patent, provided which do not unreasonably prejudice the legitimate interest of the patent owner and taking into the account to legitimate the interests of third parties. Okay, according to the Article 30 and 31, the conditions for granting a compulsory license, a government can allow the third party to produce a patented product without the patent holder's permission. Okay, so the license must be granted on a case by case basis. Then the applicant must first try to get a voluntary license from the patent holder on a reasonable terms. if it fails or negotiation fails, the government can be issued as a compulsory license except in emergencies. Okay, so and the patent holder must receive adequate compensation, that is royalties or a payment. The license must mainly serves as a domestic market. Then Article 31. Article 31B, exceptions for the national emergencies. In emergencies like pandemics, COVID, okay, pandemics or various epidemics, the government does not need to wait for the negotiations with the patent holder, or which allows for a quick access to the essential medicines or technologies. For example, during the HIV or AIDS crisis, some countries used TRIPS rules to issue the compulsory license for cheaper antiretroviral drugs. Okay, and during the COVID-19 as well, there were a discussion about using the TRIPS rule or TRIPS agreement to make the vaccines and medicines more affordable. Okay, so the TRIPS agreement protects the patent rights but allows the compulsory licensing when patent create barriers to the public access. Indian Patent Act 1970, the section or article 30 and 31 includes or follows the TRIPS while ensuring the affordable access to the essential product. Okay, the next one is under Indian national legislation. Okay, so the section 92, special provision for the compulsory license on notification by central government. Okay, compulsory license in a case of national emergency or a public interest. The central government can directly issue a compulsory license in cases of national emergencies, extreme emergencies, or a public non-commercial use like war, sudden disease outbreaks, and government programs for public welfare. The government does not have to wait for 3 years after the patent is granted. Okay, once declared as a company can apply for the license to produce the patented product. For example, if a COVID-19 vaccine is a patented but not affordable, the government can immediately issue a compulsory license so that other countries can manufacture the same drug or a compulsory licensed drug at a lower price. Then section 92(3), the circumstances of a national emergency or extreme emergency. Okay, this allows India to manufacture and export the life-saving drugs to the countries that have no manufacturing capabilities of their own or are facing the public health crisis like the epidemics. Okay, the importing country must grant a compulsory license first, and India will supply them the medicine at their lower cost. Okay, for example, India can manufacture and export the HIV medicines to the African countries where the pharmaceutical production is limited. Then, as per the section 92A, the terms and conditions for the compulsory license, any company that gets a compulsory license under section 92 pay the patent holder a fair royalty or a payment, and to produce a product mainly for the Indian market except under 92A, which allows to export, then follow the other countries set by controller of patents. Okay, for example, if an Indian company gets a license to produce a patented cancer drug, they must sell it an affordable price or pay a small royalty to the original patent holder. Then this is all about the legal provisions of compulsory license under the Paris Convention, under the TRIPS, and under the Indian national legislation. Now the provisions for compulsory license. Okay, so as per the section 84(6), the Patent Act allows the compulsory licensing if a patented product is not affordable, not available in a sufficient quantity, or not being worked in India. They must sell it an affordable price or pay a small royalty to the original patent holder. Okay, So, when deciding whether the grant of a compulsory license, the controller of a patent will consider the nature of an invention. It means how important or useful of a patented product is. Then, at the reasonable efforts, okay, whether the applicant tried to get a voluntary license from the patent holder but failed. Then, third one is public demand, whether the product is affordable or widely available to the people. Then fourth one is working of the patent in India, okay, whether the patent holder is manufacturing the product in India or just importing it. Then fifth one is patent holder justification, if the patent owner has a valid reason for not producing or supplying the product or a drug. Okay, why 84 section 84 6 section is important? To ensure the patent are used for the public benefit or to prevent the companies from blocking essential medicines or technology just by holding the patent without making them available, or to help the generic manufacturers to produce the life-saving drugs at an affordable prices. Here is the example of section 84.6. If a company holds a patent for a cancer drug but sells it at extremely high prices or does not manufacture enough to meet demand, another company can apply for a compulsory license under section 84.6. Okay, so the controller will then review the factors under 84.6 before deciding. Okay, so this is all about provision of compulsory license under section 84.6. Okay, so there is a case study regarding compulsory license, Natco versus Bear. Okay, so what is, just a minute. My screen is visible, right?
Yes, ma'am.
Okay. Sorry for the interference. Okay, so here is the case study regarding compulsory license. Okay, Natco versus Bear. Okay, so there are the key players in Natco versus Bear case. Bear AG, a German pharmaceutical giant that held a patent for the cancer drug which is marketed as a Nexavar, okay, and Natco Pharma Limited, an Indian generic pharmaceutical company that applied for a compulsory license to manufacture and sell a generic version of Nexavar. Okay, so the company the information related to both of the companies. Bayer AG, a multinational pharmaceutical and a life sciences company headquartered in Germany, which involved a healthcare, agriculture, and material science. Okay, in 1990, the Bayer Corporation invented a drug named sorafenib, which is marketed as a Nexavar for cancer patients. Okay, it not a life-saving drug, but only an extending the stage 4. Okay, it means the drug Nexavar is not life-saving, but only extend the stage 4 by 4 to 5 years among the kidney cancer patients and by 6 to 8 months among the liver cancer patients. Okay, and Natco Pharma Limited is an Indian pharmaceutical company specializing in generic drug production, particularly in oncology, neurology, and cardiology, which is based in Hyderabad. The Natco Pharmaceutical Company or the Natco Pharmaceutical Limited Company applied for a compulsory license to produce a generic version of Bayer's patented medicine Nexavar in 2011. Okay, so the timeline of this case. Okay, in 1990, the Bayer Corporation invented a drug sorafenib. sorafenib, which is marketed as a Nexavar. This is the first step in drug development process. Then in 1999, the Bayer had originally applied for the patent in United States as a sorafenib for the sorafenib. Okay, a patent application which protects a company rights over the drug or to prevent the author from making or selling it without permission. Then in 2000, Bayer filed a patent corporation treaty PCT application. A PCT application allows the companies to seek the patent protection in multiple countries through the single filing. Then in 2005, sorry, in 2005, Bayer launched the drug under the brand name Nixavar. The drug was introduced into the market for the medicinal use. Okay, and in 2008, March 2008, the Indian government granted a patent to Bayer for Nixavar. Bayer started importing and selling Nixavar in India as well. Okay, so the pricing, the cost of monthly dosage of Nixavar was 5608, approximately 8 billion, $8, that is 2.80 lakhs in India, making it very expensive for the Indian patients. Okay, this timeline is significant because it highlights the it highlights the patent process or drug commercialization and pricing issues. Okay, so then Natco Pharma Limited, an Indian pharmaceutical company, approached Bayer for seeking voluntary license to manufacture and sell sorafenib in India at lower cost. Okay, but this request was made under the Indian Patent Act 1970, which allows companies to apply for a license if a patented drug is unaffordable or unavailable to the public. Okay, Bayer was selling Nexavar at a high price. Okay, around 2.80 lakh in India. Natco's proposal, Natco's proposal to sell the drug at a lower price, that is 8,800 per month, making it more affordable for Indian patients. Then the Bayer refused the request of a Natco Pharmaceutical Limited for a voluntary license. This means the Natco could not legally manufacture or sell the drug at a lower price. Then in 2010, Cipla, MS Cipla company, the another major Indian pharmaceutical company, started selling the generic version of Nixavar. Cipla's decision to sell a generic version without Bayer's permission escalated the legal battle over the patented rights and drug affordability in India. Then in 2011, after Bayer denied the voluntary license to Natco, applied for a compulsory license to the controller of patent in India. A compulsory license which allows a company to manufacture and sell a patented product without patent holder's consent under the certain conditions. Okay, with this request was made under the section 84(1) of the Patent Act 1970, which was amended in 2005 to align with the WTO's TRIPS agreement. Okay, Natco argued the Bayer's drug was too expensive and not available to the Indian patients. Then in 2012, first compulsory license in India. This is the first case in between the Natco and Bayer for the compulsory license in India. Okay, the controller of the patent granted a first ever compulsory license in India to the Natco, which allows the Natco to manufacture and sell a generic version of Nexavar at a much lower price. Okay, Natco was required to pay Bayer at 6% of royalty on sales at the compensation. Then in 2013, IPAB means IPAB means Intellectual Property Appellate Board. Okay, Bayer had appealed to the IPAB against the grant of compulsory license to the NATCO. IPAB rejects the Bayer's appeal and upheld the controller patent's decision. As a result, NATCO was officially allowed to continue the manufacturing and selling of generic version of Nixavar in India. Okay, so the reasons for the granting of a compulsory license. Okay, first is Bayer had failed to fulfill the reasonable requirement. Okay, Bayer had not fulfilled the reasonable requirement of the public regarding its patented drug, which means the drug was not widely accessible to those who needed it. Then B point is Nexavar was unaffordable for the generic public. Okay, Bayer was selling the Nexavar at 2.8 lakh per month, which was extremely expensive. Okay, the Indian Patent Office found the drug was not available at the reasonably affordable price for many more patients. And C point is Bayer had not worked with the patent in India. Okay, as per the patent law, working means the company should manufacture or make the product available into the country where it holds as a patent. Since Bayer was importing the drug, Bayer was importing just a minute. Bayer was importing the drug instead of producing it in India. It was ruled Bayer had not worked with the patented invention of the India. Okay, as per the Section 84 in Indian Patent Act, a compulsory license can be granted if the patented drug is not available at an affordable price, the reasonable requirement of the public are not made, and the patented invention is not worked in India. Okay. So this is about timeline of case versus Natco versus Bayer. Okay. So the final conclusion is that the NATCO was officially allowed to continue the manufacturing and selling of generic version of Nixavar as per the IPAB or other Supreme Court in India. Then consideration for granting the compulsory license. As per the issue 1, Bayer failed to fulfill the reasonable requirements of the public with the regard of drug. The Indian Patent Office found the Bayer failed to ensure the drug was available to the patient who needed it. This conclusion was based on the following facts. First one is cancer patient statistics. Globocan in 2008. As per the WHO data, India has approximately 20,000 liver cancer patients and 8,900 kidney cancer patients in 2008, and Bayer estimated that 8,900 patients would need Nexavar for stage 4 cancer treatment. Then second point is Bayer supply was extremely limited. In 2011, Bayer sold only 593 boxes in Nexavar in India, and each cancer patients typically required 3 boxes. It means 3 months for the supply. Okay, and severe shortage in availability. As per the Bayer conclusion, Bayer sold the only 593 boxes. It means it only treat less than 200 patients. Okay, even using Bayer's own estimation, 8,900 patients, this means only 2% of patient got the drug. So the Bayer was unable to meet the demand for its patented drug of the Indian Patent Office determined the compulsory license was justified, and which allows the Natco Pharma Limited manufacturing and sell the drug at an affordable price, ensuring the more patients could access the life-saving treatment. Then the next issue B, Nexavar was not available at reasonably affordable prices. Okay, first one is drug prices was extremely high. Bear priced Nexavar at 2.8 lakh per month. This was not affordable for most of the Indian patients. Many people relied on private healthcare limited, which was financial support for them, and the average annual income in India was only 1,489 billion in 2013, meaning the drug cost was almost four times a person's annual income for just 1 month of the treatment. Then second point is Bear's justification for the high price. Bears argued that the high price was due to high range of R&D R&D cost. Okay, 2 billion dollars is needed to develop a new drug. Mainly failed versions of drug was created before the final one, and the failure accounted for the 70% of total R&D cost. Bear also pointed out the similar cancer drugs were priced at the similar levels globally. Despite their justification, the Indian Patent Office ruled the price was too high for the Indian patients, and this was the key reason why the compulsory license was granted to the Natco Pharma, which was reduced the cost to 120 billion per month, making the drug affordable and accessible. Okay, then the third issue C, intellectual property appellate board. As per the IPAB, the bear failed to prove that it had worked its patent in India, so no justification for manufacturing India. Bear did not provide any evidence explaining why Nexavar could not locally manufactured in India, and they also did not show why they had rely on only imports to supply to the Indian market. Okay, Bear already had manufacturing facilities in India that Natco pointed out. Bear had no production facilities in India other than other drugs, including oncology medicines, and this means Bear could have manufactured Nexavar in India but chosen not to manufacture. Okay, and third point is Bear imports were insufficient. Even if the imported stock of the Nexavar was considered, supply was too low to meet the needs of an Indian patients. The IPAB noted that the imports were nowhere near to the scale required to satisfy the public demand. Since Bear neither manufactured Nexavar in India or nor imported enough to meet the public demand, the IPAB rejected Bear's arguments, and this straightens the case for granting the compulsory license to the Natco Pharma Limited, which was ready to manufacture the drug at an affordable price in India. Okay, so the final verdict of that case, Natco versus Bayer, for the compulsory license for Nexavar drug. So first is Bayer's challenges the compulsory license. Bayer's opposed or disputed the government decision to grant a compulsory license by ordering Natco to sell the Nexavar at rupees 8,800 for monthly therapy, which is much cheaper than Bayer's price, that is 2,80,000 per month, and pay 6% of royalties to the Bayer on a total sales of that drug. Then Bayer's inaction 2008 to 2011, in 3 years, no steps no steps to change its marketing strategy or to reduce the Nexavar price to make it affordable. Okay, IPAB. So the final decision of IPAB to the Natco must increase the royalty to 7% instead of the earlier 6, and the Natco was granted only limited rights to manufacturing and sale of drug, not fully control over the drug. And the final conclusion of that case is Bayer failed to make the Nexavar accessible and affordable to the compulsory license was upheld and allowing Natco to produce a cheaper version, and the decision was landmark case in India's patent law, reinforcing the country's standard on public health over patent rights when essential drugs are unaffordable. Then The final verdict of case: no sub-licensing. NATCO cannot transfer or sub-license the compulsory license to any other company, or the license is granted only to the NATCO, meaning cannot sold or assigned to any other company, or no right to import the drug, or it must be manufactured only in India. The drug can only be used for the liver or kidney cancer disease, not for other diseases. And then NATCO cannot sell it for any other diseases. Then NATCO must provide the drug for free of cost at least to the 600 needy patients per year, which encourages the poor patients get access to the life-saving medicines. Then NATCO cannot claim that its version of the drug is identical to the Bayer's Nexavar, or it cannot advertise or promote that the drug in a way which suggests it in the same name as a Bayer's product. Okay, so the final conclusion is that the NATCO was given rights under strict condition to ensure the affordable access while protecting the bear's intellectual property, and the ruling prioritize public health but maintained some restrictions to put or to prevent the misuse of the compulsory license. So the solution for the future: to avoid the compulsory licensing, the government could create a pricing system where the drugs from the MNCs or the expensive drugs from the MNCs are sold alongside drugs made to the Indian companies, which could end the price conflicts between patented drugs and generics. Then this model ensures the affordable medicines for the poor by charging the rich to the full price, or allowing the poor patients to pay a subsidized price. Alternatively, the government could buy drugs for the poor or distribute them through the public hospitals. Implementing cost Implementing cost subsidy policies must lead to shifting focus away from complete licensing, or reducing pressure on companies to offer affordable prices, or to delay the entry of generic version, which are crucial for the long term affordability. While pricing strategies like subsidized can help in the short terms, they should not replace policies to promote the generic drug availability and compulsory license. And the government needed to strike a balance between ensuring a fair drug pricing and encouraging the innovation from the pharmaceutical companies. Thank you. This is all related to compulsory licensing. Hello, ma'am.
Hello, ma'am.
Yes.
Okay.
The second session is completed.
Okay, ma'am. Okay. Thank you, ma'am. Thank you very much. From audience, any question is there? Please, if you have any question, type into the chat box without hesitation. Audience. Okay. Ma'am, one question from our side. Hello.
Yes, ma'am. Yes.
Okay. Ma'am, info about the exim policy. What is
What,
exim
ma'am?
policy? Exim policy.
Can you please write in the chat box?
Yes, ma'am. Already question is there.
No. Just a minute, ma'am. I cannot see.
Please add information about exim policy, ma'am.
Exim policy.
Yes, ma'am.
Okay, exim policy. Okay, okay. So, exim policy is a set guidelines or instructions from the Indian government which governs the import and export of a goods and services, which aim to regulating the drug to the foreign trades. It means to facilitate the imports into the imports and exports from the India, or to promote the balanced trade environment and support the economic growth.
Okay, ma'am. Okay.
Yeah. Any
Next
other
question
question?
is, ma'am. Yes, ma'am. Other one question is there.
Yeah.
How to protect our innovation, like patent?
Uh, can I explain in Hindi or Marathi?
Yes, ma'am.
या हां. आता इफ तुमचं इनोव्हेशन आता समजा न्यू आहे, ओके. सो
Okay.
सगळ्यात आधी तुम्हाला ते पेटेंटमध्ये तुम्हाला म्हणजे पेटेंटमध्ये पब्लिश किंवा मग ग्रांट करावं लागेल. इफ समजा तुम्ही आता त्याचं रिसर्च आर्टिकल और रिव्ह्यू आर्टिकल जर तुम्ही पब्लिश केला तर ते ऑलरेडी डिस्क्लोज होऊन जाईल, म्हणजे प्रायर आर्टमध्ये येऊन जाईल, राईट.
Okay.
त्याच्यामुळे कधी जर तुमचं इनोव्हेशन आता समजा तुमचं इनोव्हेशन न्यू वगैरे असेल तर तुम्ही जे पण पेटेंट अटॉर्नी वगैरे असतील त्यांना मग तुमचं इनोव्हेशन तुम्ही पाठवायला पाहिजे आणि मग ते पेटेंट सर्चिंग करणार, म्हणजे पेटेंटॅबिलिटी क्रायटेरिया वाईज ते पेटेंट सर्चिंग करणार आणि त्यावेळेस तुम्हाला सांगणार की तुमचं इनोव्हेशन जे आहे ते इनोव्हेटिव्ह और न्यू आहे का किंवा त्याच्या रिलेटेड कुठले म्हणजे आधीचे प्रायर आर्ट्स वगैरे आहेत का. जर नसतील तर मग तुम्ही ते पुढे घेऊन जाऊ शकता आणि पेटेंट पब्लिश झाल्यानंतरच तुम्ही मग रिसर्च आर्टिकल और रिव्ह्यू आर्टिकल त्यावर तुम्ही पब्लिश करू शकता असं.
अच्छा मॅम. इट मीन्स की जे पब्लिकेशन करायचे आहे आपल्याला ते पेपर पब्लिश करण्याच्या आधीच करावं लागेल आणि त्याच्यानंतर पेपर पब्लिश करायला लागेल.
बिकॉज तुम्ही पेपर पब्लिश केला तर मग ते ऍज अ प्रायर आर्ट म्हणून तुमच्या पेटेंट पब्लिकेशनला प्रॉब्लेम येऊ शकतो.
ओके मॅम. ओके.
म्हणजे जेव्हा
थँक्यू
पण
मॅम.
हिअरिंग लागते तेव्हा प्रॉब्लेम येऊ शकतो.
Okay, okay, okay. Thank you, ma'am. Other question from audience? Okay. Thank you, ma'am, for your such a beautiful presentation. Also for giving all legal information about the licensing, like voluntary license and compulsory license. Also for providing brief agenda about the case study. So I'm very thankful to you, ma'am. Thank you once again.
Thank you for listening me. Thank you so much.
Okay, ma'am. Now we will take a lunch break. The next session will start at 2 p.m. So new link will be provided into our WhatsApp group. So everyone join within 10 minutes after the providing link. So thank you.